Leading off our next session is Nicole Bearce from Lowenstein Sandler in New Jersey. Nicole handles high-stakes, complex commercial matters, including pharmaceutical and mass tort litigation, as well as other commercial litigation. Nicole received her law degree from Harvard University, which I understand is one of the 5 top law schools in the Boston area. Sorry, Nicole and I are friends, and she'll kill me for saying that, but I'll have to pay for it later. Nicole is here to discuss the art of dealing with former and current employees in litigation. Please welcome Nicole Bearce.
Hi, good morning. To the fact finder, whether a judge or a jury, a company comes to court through the witnesses who speak on its behalf. And that is because we all know that a corporation is a legal fiction. It is one of the most well-recognized legal fictions, but a fiction nonetheless. And while a corporation can do many of the things that a person can do under the law, when a company is sued, when it comes down to it, it is the individuals who appear at that trial and who are involved in preparing that defense who are going to carry the day. Now, you will find, and I'm sure many in the room have found, that oftentimes it is not only current employees, but it is frequently former employees who play the role of key fact witnesses, who may be named as co-defendants, and even if they're not testifying at trial, these employees may be involved behind the scenes because they may have critical historical information about things that no current employee has in their memory, and they may need to be part of that defense team to help your legal team put together the most effective presentation that they can. And in a climate when many companies have gone through reductions in force, you may find yourself dealing with some tricky issues when you are dealing with current and former employees in litigation. So while there are a whole host of ethical issues that may arise in that context, there are 3 principal ones that I'm going to focus on here this morning. Let's see, I have tried to tee them up by putting questions that you might commonly hear yourself. The first cluster of questions is, who's going to represent me, and do I need my own lawyer? Now, from an ethical standpoint, these questions raise the prospect of joint representation and potential conflict of interest issues. And of course, whether there is a potential conflict of interest is something that needs to be analyzed before joint representation is undertaken. And something that I will reiterate a couple of times, that analysis needs to be revisited throughout the course of the litigation. And that is because circumstances change. We all know that. And when circumstances change, whether or not there is a conflict or the potential for a conflict can also change down the road. So it's something that you want to be vigilant about, and you want to revisit it throughout the course of a proceeding. You may also need to obtain written informed consent, and I will touch on that. The second question is, who's going to pay for my lawyer? And I will talk about indemnification and advancement of legal fees, and when is it allowed and when it is not. And finally, something that I know I hear commonly, I would estimate, can you guys hear me? About 50% of my cases when dealing with former employees, I get asked, they'll say, I left the company years ago, can I get paid for my time? It is a very common question. And I will say that it depends on which jurisdiction you are in as to whether or not that is permitted to happen. And I'm going to talk about that. And I'm also going to talk about, if it is permitted, how much can you pay? Okay, so the first cluster of issues is raised by the question, can the same attorney represent the company and the employee? And when you're asked that question, it makes sense to go back to the rule to see what's applicable. And here I've highlighted New Jersey's RPC 1.7. It's based on the model rule. It's similar in many other jurisdictions. You want to make sure that you are aware of what the governing rule is where you are practicing. Now, RPC 1.7 prohibits joint representation where there is a concurrent conflict of interest. So what does that mean? It means either the representation of one client will be directly adverse to another client. I think that one's pretty easy. The second one is where there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, a third person, or a personal interest of the lawyer. So that means if the lawyer is going to somehow be impeded from zealously advocating on behalf of one client because of the responsibilities that that lawyer holds to another client, then there is a concurrent conflict of interest. Now, typically, the interest of an employee who's named as a defendant in a lawsuit will be aligned with that of the company as long as the employee was acting within the scope of his or her responsibilities. That said, of course, there are circumstances where conflicts can arise, and I've listed a few on the slide that's up on the screen. I'll list them in, or talk about them in reverse order. The one that's most obvious, if there are criminal allegations and an individual may face jail time, of course, you need independent, separate counsel in that circumstance. You may also have a circumstance where there are no criminal allegations, but there are claims alleging intentional misconduct of an employee. This is a situation where you want to be really careful and scrutinize the facts and circumstances, because if there is a possibility that there is going to be a divergence of interest down the road, you want to think long and hard whether or not it makes sense to undertake joint representation. And I will make a point here to say, here I'm talking about where an individual employee is named as a co-defendant. You may, of course, also have circumstances where there is, at least not yet, an individual who's been named as a co-defendant, but there are still allegations out there about intentional misconduct. And you may need to do some internal investigation to figure out what the facts on the ground are. If that is the situation, then to comply with your ethical obligations, if you are interviewing individual employees, you will want to make sure that you provide them with upjohn warnings so that they recognize that while your communications are privileged, the privilege belongs to the company. And that means that down the road, depending on what is uncovered, it may be that the company decides to waive that privilege and disclose the information. And we could probably spend a whole presentation just on upjohn warnings. But for the purposes here, I'm focusing on when an individual employee is named as a co-defendant and there are claims of intentional misconduct. It's not a necessity to have separate counsel, but you want to think long and hard about whether or not the benefits and risks outweigh one another. And the third instance that I have here, there are certain causes of action where the doctrine of respondeat superior doesn't apply. Typically, I've seen this actually where you've had civil rights actions asserted against government employers where there are also individual employees named. And there are some jurisdictions that have found that it's per se prohibited to have the same lawyer represent the employer as well as the employee. And then there are other courts that haven't gone that far, but they have said you need to look to see whether there is a substantial identity of interests, which means you look to see if there are common defenses that the various defendants are going to be asserting. And if there is going to be a divergence of interest down the road, then again, you want to think long and hard about bringing in separate counsel. Now, if there is a potential conflict of interest, RPC 1.7b indicates that a lawyer may still undertake joint representation, but here are the requirements. First, the lawyer must provide informed consent to each, well, the client must provide informed consent. The lawyer must provide adequate disclosure of the material risks and the available alternatives to that individual so that the clients can provide informed consent. It would be best practice to confirm that in writing. Oftentimes that's done in the course of an engagement letter. The lawyer must reasonably believe that he or she will be able to provide competent and diligent representation to each client. The representation, of course, cannot be prohibited by law, and the representation may not involve the assertion of a claim by one client against the other. Now, there are a number of reasons why it makes sense to undertake joint representation. It maintains control over the defense, it can streamline costs, it can keep employees, quote unquote, under the tent. It can promote a unified defense strategy. But again, you want to make sure that you're really weighing the benefits against the risks to determine whether or not it makes the most sense to proceed in that fashion. And if circumstances change throughout the course of the litigation, you want to revisit it. Now, I realize I'm focusing on the ethical issues here and not the practicality of having a very sort of difficult and delicate conversation with an individual who you may be advising that they may need independent counsel. We could probably spend more than just one more session on that particular topic. But these are the ethical responsibilities on your end that you need to keep in mind. And I will point out that informed consent is something that's looked at on an individual fact-specific basis in each case, and the burden falls on the attorney to demonstrate that informed consent was obtained if an issue arises down the road. Now, there have been specific disclaimers that have been included in engagement letters that courts have looked at, but they've reached different conclusions, again, depending on what the individual facts are in a particular case. And I have two up on the slide now, and I'll explain the difference here. There was a disclaimer, it was comparable language in each of the engagement letters that said, at the present time, we do not see any conflict that would prevent the firm from representing both the corporation and employee. It is possible, however, that such a conflict may arise or become apparent in the future, in which case it is understood that the employee would retain separate counsel and that the firm would continue to represent the corporation. Now, in the Rite Aid securities class action litigation, the court looked at that kind of disclaimer language and found that it was indicative of the CEO in that case had signed off on that language in an engagement letter where the law firm representing Rite Aid also represented the CEO. During the course of the case, there was a partial settlement reached with Rite Aid, but there had been the discovery of some questionable conduct on the part of the CEO. He was not involved in the settlement. When the case against him proceeded, he moved to disqualify the law firm that had been representing Rite Aid, and the court denied it, found that disqualification was not necessary, and looked in part to this disclaimer language that was included in the engagement letter. The Touchcom case that I have noted up on the slide, the court reached a different conclusion, but it was a different set of facts. There had been a patent infringement case that had been filed by Touchcom against another company, and its patent was obviously at issue. Its patent agent was deposed during that litigation, and while the patent agent worked for a different company, it was Touchcom's counsel who represented that patent agent in his deposition. Well, that court case actually resulted in finding that the patent was invalid. So not surprisingly, Touchcom then turned around and filed a malpractice case against the patent agent and its firm. In that case, the patent agent moved to disqualify Touchcom's counsel from continuing to represent the company because he said that he disclosed confidential information to that counsel while he had been prepared for his deposition in the separate infringement action. So these are things that you need to think about because you don't want to be in a situation where you've paid lots and lots of money to a law firm and then a conflict arises and they end up getting disqualified and then you're sent back to the drawing board. Indemnification and advancement of legal fees. Most states have statutes that authorize indemnification under certain circumstances. I have up on the screen the Delaware statute. It's the model for many other statutes, and many companies are Delaware corporations. And that allows indemnification if the person acts in good faith and in a manner that they reasonably believe to be in or at least not opposed to the best interests of the corporation. This essentially means that, again, as long as employees are acting within the scope of their official responsibilities, typically indemnification is proper. And in fact, there's case law that says that indemnification is mandatory if an officer or director is successful in litigation on the merits, which can include settlement for dismissal with prejudice. Now, keep in mind that companies, this is the New Jersey statute, rather, that I included in the materials, and then the Delaware statute. Keep in mind that rights of indemnification can be modified and addressed in a company's certificate of incorporation and bylaws. So you want to know what your company's certificate of incorporation and bylaws provide. It's important to understand what the governing authority is. And as long as that does not run counter to applicable state statutes, that would obviously govern your particular situation. Now, in Delaware, the statutes provide that an employee cannot be indemnified if they are found to have violated the duty of good faith. In New Jersey, an employee cannot be indemnified if they have been found to have breached the duty of loyalty, if they have not acted in good faith or knowingly violated the law, or in some other way received an improper personal benefit. Advancement of fees is different. Advancement of fees is different in that rather than waiting until the end of a case and having the individual employee submit all of the bills that they paid and asking for reimbursement, advancement is a situation where you have an employee that submits the bills as they're being incurred. Now, that is something that companies can do, but that's discretionary. There's no authority out there that would be an obligation. But keep in mind, some state statutes require that an employee post an undertaking that would require repayment if it is found down the road that the employee should not have received indemnification. And I have cited on the slide the New Jersey and the Delaware statutes to that effect. I have actually not run into that actually happening in any of my cases, but I know clients who have told me that they have done this and they have had employees posted undertakings, so it's something you want to be aware of. Now, the way that issues 1 and 2 relate to one another is if you decide that joint representation is not the best course of action, it is not uncommon to have the company hire another lawyer to represent an individual employee but still continue to pay the legal bills. You want to keep in mind that that raises a potential problem under RPC 1.8F, okay, which prohibits an attorney from accepting payment from a third party other than the client unless the client, again, gives informed consent, there is no interference with the lawyer's independence of professional judgment, and information relating to representation of the client is protected as required by RPC 1.6. And 1.6 requires that you maintain the confidentiality of communications with your client. There was a case in New Jersey that I have up on the screen where the court sort of wrangled with the interplay of these different RPCs, where there was a grand jury investigation of an employer that required the testimony of individual employees. And the company hired separate counsel for the employees and paid the bills for those employees to testify before the grand jury. The state didn't like that, and they challenged it, and they moved to disqualify those law firms. The trial court had upheld it as appropriate. The Supreme Court of New Jersey also affirmed, and in an opinion written by Justice Rivera-Soto, laid out several different criteria that needed to be met in that context. And things to keep in mind was, because the confidentiality needed to be maintained, the court recognized that the law firms in that situation, rather than including detailed entries that you would see in a typical legal bill, they just did line item entries so that the company didn't see the specifics of what the firm was doing. Something else that I wanted to focus on here is there was a requirement, number 3, that there be no current attorney-client relationship between the lawyer and the third-party payer. So let me just point out what this means. If you have a situation where your company has a preferred counsel program or a limited number of firms that you're working with, it may seem really ordinary if you've got one firm that's conflicted out of representing an individual to turn to one of your other firms to handle that situation. Well, the court in the New Jersey case basically found that if there was a pre-existing relationship, that would not comply with the criteria where you're dealing with this tricky issue of having the company pay the legal bills for its individual employees. So it would be best to go to a firm with which you have not had prior experience or you don't have at least a current relationship. So that's something to keep in mind. Finally, can you pay former employees for their testimony as a fact witness? This depends on the jurisdiction in which you are sitting. Now, it is not an unreasonable request to ask to be paid for your time. But going back more than a century, historically, it was actually viewed as really part of your civic duty to appear in a court case if you had personal knowledge that was relevant to an action. It was similar to appearing for jury duty. And the idea of getting paid for that was viewed as inappropriate because it could taint your testimony. And I will say, putting aside ethical issues, paying a witness at any time, and I'm not talking about expert witnesses here, I'm talking about fact witnesses, you want to be careful when you're compensating them no matter what jurisdiction you're in because they can be subject to cross-examination due to bias. But beyond that, there are jurisdictions, New Jersey is one of them, that has actually found that it is against public policy to compensate fact witnesses when they are appearing for trial. I have up here quotes from a New York and a Delaware case that have actually come up a little bit more into the modern times and taken a more realistic, I think, and nuanced approach to this. But New Jersey has a much stricter approach. There have also been a couple of subsequent cases that have cited to the New Jersey case of Goldstein versus Exxon Research. One instance, we had a pro hoc vice admission of an attorney from outside of the state that was actually revoked as a result of offering to compensate witnesses. There was a little bit more going on there, and there was a genuine aura, I think, of tampering with witnesses, but it's something, again, to be mindful of. And I realize that I am almost out of time, so I will point out that in the materials that I've included, you want to be mindful of 4 different categories of expenses or payment for fact witnesses. You've got out-of-pocket expenses and mileage, which I think in any jurisdiction is okay. You also have witnesses who will not appear you have employees who will not appear as fact witnesses, but may help your defense team be educated so that they can understand documents, historical operations, other issues that they'll need to put together a defense. That is typically okay as well. Where you come into sort of tricky issues is when you're compensating an employee who will testify, and jurisdictions are split as to whether or not you can pay for preparation and whether you can pay for time when they're actually testifying. So you want to be sure that you're clear where you are litigating. If in New Jersey, I would say don't do it. If you're in New York, you can probably do it. But again, you want the compensation to be reasonable, and you want to memorialize it in a consulting agreement so it's clear what the witnesses are doing for you. So with that, thank you for your time.